Appropriate on a morning that we're going to be talking about death, that the Phillies are dead and the Eagles look like they're dead, but you, you, you know, I guess it's appropriate, so we'll try to stay alive on this Monday morning. But welcome everybody. Dave Honorado with the law firm of Laddick, Honorado and Fetterman. We're in North Wales. We have a general practice, and I specialize in municipal zoning and land development work, and I also do estate planning and estate administration. And I'm really pleased that Janet Amaker joined us this summer. And Janet specializes in estate planning and estate administration solely, and I'll let Janet introduce herself before we go forward.
Morning. Thank you for having us. I was happy to join Dave in the end of June. I've been a solo practitioner since 2004 when I left the partnership in Norristown, came out here to North Wales. I saw an opportunity to join a very good firm, get more support for myself and for my staff. And it's been a perfect fit, at least from my perspective, going forward. Like Dave said, I do practice solely now in estate planning and estate administration. I have an LLM in tax, which was very important back when the federal exemption was lower, and we'll touch on that briefly. It may become important again, depending on what happens with the political scheme going forward with regard to the federal death tax. So thank you for having me.
Welcome, Janet. So with that, so we only have a few minutes, so we can't get too deep into the weeds, but what we kick around all the time is what are the special needs that a small business or family business may have to consider when we do some estate planning for them. Certainly that is different than when the run-of-the-mill mom and dad come in to see us, and when we do what would be a simplified estate plan for those folks. But in the business setting, in a small business, it may be the major asset that that business owner or owners have. And so there are concerns with regard to transfer of control and succession planning. So we always ask, what is the plan, if there is one? How do they plan to succeed? It's important to know whether it's a family-owned business or a sole proprietorship, or whether it's a company that has other non-related parties that their interests would have to be taken into consideration if there's a death of a partner or a shareholder. And obviously we get into issues and discussions with regard to if there's life insurance in place to handle the transfer, the payment of the transfer of the ownership interest. Is there a provision for valuation of that ownership interest? So all of these things come into place, and we ask our clients to try to think about that sooner rather than later. So the appropriate documents are in place to help them if and when the inevitable happens. Before we get into that, just wanted to touch on, for those that may need it. Obviously, we do estate planning, and Janet does most of that for us, but there are some basic documents that we recommend for everyone, regardless of whether they have a business or not, and that would be obviously the will and power of attorney and a medical power of attorney / advance directive. And I'll let Janet just explain briefly how all those interrelate and work together, and why we recommend them for the average husband and wife or partner situation that comes in to see us.
So you're familiar with the will. The will is, in most people's thoughts, is how they transfer what they own at their death, but there really has many other important components as well. When somebody passes, property passes from them to others in one of three ways, and the will is surprisingly the last way, or the least common way, because two other ways trump the will. One is title, and that is how an asset is named, either with a spouse or with another family member, and that's commonly the deed to the home or a bank account. So the title trumps the will. And the second way property passes is by beneficiary designation, and most commonly think of that as life insurance or IRAs or 401ks. But there are circumstances where folks will actually put a transfer on death designation on an account, and that would trump the will as well. So it's important to realize that the will take care of transferring your property, but if you've done those other ways, those will take precedence. The will names your executor. That's very important. It's the person who will manage your affairs, wrap up your affairs, pay your debts, pay your taxes, file your inheritance tax return. It also talks about where the tax source of the tax payment is coming. The inheritance tax in Pennsylvania is 4.5% on a lineal basis, but it has to come from somewhere. And if you have beneficiary designations on accounts, then those accounts are not available to pay those taxes, or if it's coming from life insurance that has a beneficiary, that beneficiary has no duty to pay those taxes. So the will has a clause in it that either says it comes out of the residue or it comes from the beneficiary who is receiving the asset, and that's very, very important. The other important component of the will is the waiver of the bond. If you have an executor who is not a Pennsylvania resident, they must be bonded. It means buying an insurance policy on themselves, yearly annual premium, multiple thousands of dollars, and that's unnecessary because the will can waive that bond. And then obviously the will transfers your assets. It tells to whom they go and what proportions. It might give a specific bequest of a dollar amount. It might give a charitable bequest. It has all kinds of possibilities with regard to transfer. Power of attorney is a good news. You're alive when this one is working for you. This is where you name an agent to manage your legal and financial matters, should you want them to, more importantly, should you need them to. And many people think this is a document that really shouldn't come into play until they're in an advanced age and susceptible to some mental problems. But it really is a document that you should have from the moment you're of majority. Somebody has to be named so that there's not a court battle. I had a case where we were in court for 5 years over a battle to a young man who had an accident and became comatose, and the mother and the daughter and his wife didn't get along before that happened. And they certainly didn't get along after it happened. And about $400,000 of legal fees later, the judge made them co-guardians, which was not the right result either. So if he'd had a power of attorney, it wouldn't have mattered if he picked his wife or his mother, but it would have avoided all of that. That's just for legal and financial. And then Pennsylvania's document for medical is called its healthcare power of attorney. Obviously, you name somebody in that document to make a medical decision for you. It trumps the HIPAA rules. It can make a child, it can make a spouse, it can make anybody you wish to be your agent. And the second part of it is a living will. Some states have a separate living will from their healthcare power. We combine ours together, and Pennsylvania asks and poses the very difficult questions and wants you to answer them. That if you were in a permanent vegetative state with no hope of recovery, what sorts of medical treatment would you like to have administered to prolong your life? There's no right or wrong answer. It also asks you whether your healthcare agent must follow your instructions or if those instructions are for guidance and your healthcare agent has the final say. So that's a summary of the 3 documents that we consider a package when folks come in, whether it's for business owners or just regular folks off the street.
So having gone over that, there are some special considerations, obviously, if a business is involved. And as I'm sure you all know, there's different forms of ownership of business. I guess the first to consider whether or not it's just a sole proprietor, individual who owns and runs a business. But also businesses could be in the form of a partnership, either a family limited partnership or a partnership with third parties, as well as in the corporate form, whether it's a C Corp, S Corp, or LLC. So knowing that and understanding that will impact the estate plan, and it's often a consideration if the business hasn't been formed yet as to which form to select will help in the future with respect to those issues we're going to discuss briefly today. So, and many of these agreements are the same or similar. A shareholders agreement and a partnership agreement attempt to do the same things, and that's to provide for the transfer of ownership. And we certainly recommend that if you are in business with someone else, not a family member, that you have a shareholders agreement or partnership agreement, depending on your form of ownership. So, Janet, just if you could just tell us what you think about the importance of having either of those agreements, depending on the form of ownership and what they do and try to do for a business.
Well, the main purpose, and folks who are sophisticated enough to know they should form some sort of entity, is to protect them from personal liability. If I'm an LLC or I'm an S Corp and I conduct my business and for some reason my actions or an employee's actions of mine cause harm to somebody or to property, then my business is liable for the harm, but I'm not personally liable. So we call it the corporate veil, or when it doesn't work, it's called piercing the corporate veil. So forming an entity puts a wall between you and the public so that if something does go south, your personal assets are not at risk. Those commonly, even if you're a solo practitioner, can be an LLC or an S Corp. You don't have to have multiple partners to form an entity. You can be an entity by yourself. If you are not an entity, then you're a sole proprietor. For tax purposes, you can be taxed as an S Corp or an LLC, but it doesn't give you any protection unless you actually form those entities. Sole proprietors, they're the mom, they're the dad, they own the business, and at their death, the ownership of that business will transfer according to their will. To touch on one other quick thing, sole proprietor is an example. If you have no will, the state does not take your money. People walk in and say, I need a will because if I don't have one, Pennsylvania will get what I have, and that's absolutely not untrue. However, Pennsylvania does have a statute of descent, and the statute of descent is what kicks in when you don't have a will. And now you no longer have any say in who gets what, nor do any of your family members. The statute of descent starts with, do you have a spouse? And if you do, your spouse takes your share. If you have a spouse and children, the spouse gets half and the children get half. If you have no spouse and no children, your parents take. If you have no parents, then your aunts and uncles take. If you have, then your siblings take, no siblings, and so on. So it goes out to about three degrees. Your second cousins would be your last statutory heirs if you do not have a will. You're in a partnership. Now this is getting where the fun starts. Partner passes away and they have a verbal agreement between themselves, maybe two, maybe three. This is what I want to happen if I die. Oh, sure. Don't worry, that's never going to happen. I want you to do this and you to do this. Well, if that's not in writing, none of that's going to happen. And the family members who got along well when you were in your partnership may not be happy now. If your will is in effect and you leave everything to your spouse, then your partners have your spouse as their new partner, which may or may not work. There has to be liquidity if you want to buy each other out of your partnership interest. We talk about the 3 Ds, death, disability, and divorce. Some of that can be funded through life insurance. Dave, I'll let you take it from there.
Great. So what we see in looking at either a partnership agreement or a shareholders agreement is whether it's a cross-purchase agreement or a redemption agreement or a hybrid of those two. A cross-purchase agreement, as Janet alluded to, would be if your partners are going to buy you out, and a redemption agreement would be if the entity is going to buy you out. And in many agreements that we see, it's usually a hybrid that gives the partners, shareholders, an opportunity to buy in a proportionate share to their ownership of the company by your interest. And if they choose not to do that, then the entity is required to do that. And that can occur both at retirement or some other election to leave the company or at death. There are some tax considerations with regard to that. With a cross-purchase agreement, generally, the owners that purchase your interest would get essentially a stepped-up basis or for the valuation of your share of the company when they purchase it. If the entity buys it, then that wouldn't happen. The other big consideration would be how is this being funded? So if it's transfer before death, usually these agreements have a buyout provision that goes for a number of years, 5 or 10 years. And it's, so there's time for either the entity or the shareholders to come up with those funds over that period of time. If it's a death situation, then that's usually not the case. Or if it is, there's got to be ability for the survivors to afford to do that. And one of the ways to do that would be to have insurance. So now if, for instance, in the cross-purchase agreement and you have multiple partners, each of you are responsible for buying out your dead partner's share. You each would want to have insurance, your own insurance policy on that dead partner. So you could have multiple insurance policies that are required to be purchased each and every year, which could get expensive and tedious to try to have that in effect. Whereas if it's a redemption agreement, the entity would buy the insurance and pay for the insurance and buy out your partner's share at the time of your death. Jan, do you have anything to add to that?
No, one of the other, before we move on to valuation, another source of transfer can be gifting. And gifting is something that I have family businesses do, where they come in and say, I'd like to start to transfer the business to my daughter or to my children. Of course, I want to retain control, so we're not going to give away more than 51%. But that's something where we have, Dave will touch on this valuation piece, we have a valuation done of the business, and we know the number of outstanding shares and how many the proprietor owns or that business owner owns. And then we do a division so that we can start to gift out to children, multiple or single or one child, enough so that we don't have to do gift tax reporting every year. And without getting into the weeds on gift tax, we all know that you can give $15,000 or less every year without filing a return. You're never paying tax when you file a gift tax return. You're simply reporting to the federal government that you've made a gift and how much it was. And you must do that for every gift that's in excess of $15,000. So if we can keep the annual giving at $15,000 or less, or we decide we want to make a bigger gift, then we just simply file the return that reports the amount of the gift. Dave will tell you about the valuations. Your agreement should have a source of valuation determination in it. Sometimes it'll have something called Exhibit A, which is the value at the time. And then that is revisited annually. But as Dave and I know, most people don't revisit that, just like they don't keep up their corporate kit and they don't keep their minutes until they're sued. And then we have to retroactively recreate minutes for them. But we'll let Dave talk about the valuation.
So thank you, Janet. So many agreements will have a provision in there for how the shareholder or partnership interest is to be valued. Oftentimes there's an agreed value. So each year, the partners, shareholders are supposed to get together with some reasonable basis, determine the value of the company and state that. And so everybody agrees that this is the value. And if one of us goes this next year, this is the value of my share. And as long as that value has some, like I said, some basis of fact, some accounting principle, it's generally accepted as a fair valuation for the company. But as Janet mentioned, people sign agreements, shareholders, partnership agreements, they throw them in a drawer or in a binder and then don't go back to it. And that is often has not been done. We also see basis of a formula that is used to value. So at the time of someone's death, you go to the formula, it's attached, and you follow the formula to determine what the value of the partnership interest is. And then the other way that's done, and maybe the best way, probably it's more costly, obviously, would be an appraisal of the company. And that's done by business appraisal, and it's either agreed upon, or sometimes there may be a requirement to have 2 appraisals or 3, and that all is necessary if you're going to transfer interest at the time of someone's death. You have to know what the value is. So you have to consider those things, and the agreements usually have one of these options in there so that we know how we're going to do it. So there are some impacts to that with regard to estate tax potentially if the company was undervalued at the time of the transfer. And certainly there's the possibility that the agreed upon value may be higher or lower than what the interest really is. So there's some situations and considerations to have with regard to determining the method of valuation and how it's done. Do you want to add anything to that, Janet?
Yes, it often comes up that when it's time to report the asset, the value on an inheritance tax return, the family would like to minimize that value when there are a few discounts that are allowed. One's called the lack of control discount. The other's the lack of marketability. Nobody is going to, other than the partners, are going to buy this interest, so it gets devalued for that purpose. But on the other hand, when it's time for the selling family to get compensated, they don't want any discounts. They want the full-blown value, even though on the inheritance tax return they may have wanted to report it at a lesser value. So you have to realize you can't have it both ways.
We touched on liquidity issues. We touched on life insurance and the necessity for life insurance. Certainly our recommendation would be to have life insurance so that at the time of death there is monies there, that if there's extra cash, you certainly can rely on that, but many people don't have that. So there should be insurance in place to pay for this transfer of ownership interest. And we also talked about structured payments that are often provided for in these agreements. So there are two ways to deal with liquidity issues. Janet, what other estate or PA inheritance tax issues would be of a concern at the time of?
Let's talk about the death tax. There are two kinds, and they're confused and they're mixed up. People come in and say, "Well, I heard that the Pennsylvania inheritance tax, we don't have that anymore." And I'll say, "Well, that's not true. You're thinking about the federal death tax. That's called the estate tax. The federal death tax is called the estate tax. We still have it, but as I mentioned earlier, each of us has an exemption, an amount we're allowed to die with before the federal government wants to have an interest in what we have. And that's currently $11.2 million. The other thing that happened when that amount was increased is that the Congress gave us what's called portability, which is something we had never had before and something we were kind of amazed that they did. Portability simply says that I get my spouse's unused portion. So if my spouse is worth $2 million and he dies, then I have $9 million of his plus my $11 million. So now I have $20.4 million of my own. That has taken many folks out of the federal death tax picture. A large part of my practice before this exemption went so high was life insurance trusts, all kinds of ways to fund the payment of the tax. None of that is very common anymore. The Pennsylvania inheritance tax did not go away. We don't see it going away. We have a tax between spouses, which is absolutely crazy, because when you look on a return, if you transfer anything to your spouse, the spousal rate of tax is 0. Why we say we have an inheritance tax between spouses, I don't know, because when you multiply 0 times anything, you're going to get a 0. The lineal rate, children, grandchildren, parents, is 4.5%. The sibling rate is 12%, and that this kicks in partnerships quite often because we're family LLCs, because it's often brothers and sisters who are the partners. That's a 12% rate, so somebody better be thinking about where the source of that tax is going to come. And anybody else in the world, no matter how much I love them and they love me, it's 15%. So if I'm leaving assets to other folks, they're going to be taxed at that rate. That having been said, Pennsylvania gave us a break in 2012, went into effect in 2013, for what's called a qualified family-owned business exemption. And that's, there's a lot of bells and whistles and hoops you have to jump through. First of all, the book value can't be more than $5 million. The transfer has to stay within the family. Family is defined. And it also has to remain in the family for 7 years. If you transfer it to your family through your will or through an agreement, they must certify that those then business owners or partners or shareholders have to certify to the Department of Revenue every year that they continue to own those shares and that there have been no outsiders brought into the family business. If you meet all those bells and whistles, then there is a complete exemption from inheritance tax on that family asset.
Well, I think we gave you all a lot to think about. I think some of you are in the financial industry, so I'm sure you have dealt with these issues with your clients and helping them with their financial plans. So, Pam, we're available for questions at this point.
Yes, thank you, Janet and Dave. It's a great presentation. A lot to think about, a lot of information compacted in a short amount of time. So thank you for spending the time to give us that summary. Anyone, any thoughts, any questions for David and Janet?
I do have one. It may seem like a crazy question. Hey, Janet, my question was pretty quick. In that last scenario you gave, with families having to certify that they've been in business for seven years, what's the penalty?
That's a good question. It immediately reverts back to the date of death of the business owner, and the value of what was transferred from that owner is then taxed at the rate at that date.
Okay, thank you.
A look back.
Thank you.
Anyone else? Janet, I did have a question about the medical power of attorney. So the situation where the individual is not in a position to be able to make decisions on their own, medical power of attorney was established. That person has since passed. It was a sibling, and so just curious as to how somebody jumps into take. Okay.
The power has the ability, the form itself has the agent's name, and then it has first alternative agent and second alternative agent. So if it was prepared properly, there would have been a backup. I never write a document where there's not a backup executor, a backup agent, a backup healthcare agent. To the extent they want a second, that's up to them. Sometimes folks will have joint agents, and this is important to know. They'll say, my spouse died, but I want my children. I have one now where they have 5 children, and they want them all to be co-agents. When you have multiple agents, the document has to provide how they act. And your choices are, do they act separately and independently, meaning one can act without the other, or do they have to act jointly? And if there's more than 2, do they have to act by unanimity or by majority? Without an agent, my understanding is doctors are required to keep you alive.
Thank you. Anyone else?
I do have a question, Pam, sorry. You were talking about if the executors are out of state, not in Pennsylvania, that they need to be bonded.
Yes.
And I thought I heard you say that might have some flexibility. Did I misunderstand? Could you explain that a little bit more, please?
It has to, the will, a well-written will say, will waive the bond, will say no security needs to be provided or no bonding needs to be provided for my executor. There's a clause in the executor appointment paragraph that should address that. And it's always humorous when people come in with wills from the internet and the parts that are missing, because all they think is, where does my stuff go and who's my executor? And they don't think about these other pieces. But if the will waives the bond, then that's great, that's fine.
Okay, thank you.
I had a question about the family or willing it over to the family. You said that the family was defined. Is that also to the extent of second cousins as
no, it's
you were meant, or is that different definition?
It's not. And I have the piece of the statute here in front of me. I'm trying to think. It also talks about how many employees you have to have. Let me see if I can see exactly who these folks are. I'll follow up with you on that.
Sorry.
Yeah, it's. I doubt that it goes out that far. It's usually siblings, children, grandchildren, parents.
Okay, more closed loop. Okay, got it. Thank you.
Any other thoughts? If not, I'd like to say thank you again to David and Janet for your presentation this morning, for everybody for joining us. Our next meeting is October 26th, again, 9 a.m., and look forward to seeing you then, but hopefully sometime in between. So have a great week, and look forward to seeing you soon. Thanks again for joining us.
Thank you.
Thank you
Phil.
all.
Thank you. Thanks,
Yeah.
everybody. Have a great week.
Dave,
Bye-bye.
Janet, thanks a lot. It was great.